Good afternoon. I am Kenya Desatel. I am a COPA board member and chairperson of the Education and Advocacy Committee, and I'm very pleased to welcome you all to our first webinar of 2021. Most, if not all of you, know that COPA advocates for the O&P profession at the state level within California. And as an organization, we are really focused on synthesizing relevant and unique information to positively influence our members and the larger O&P community, but especially within California. Despite the many obstacles 2020 threw all of our ways, we were able to make great strides as the world, the pandemic, and our organization evolve. We continue to adapt to provide the most valuable member experience. We organized Zoom calls with state legislators to familiarize them with our profession, helping them to understand the significance of the care and services we provide. And our Education and Advocacy Committee began offering webinars to provide more educational opportunities throughout the year. In total, last year we hosted 4 webinars, all of which were a tremendous success and have encouraged us to continue with this endeavor, hence why you're all here. This year, we plan on increasing the diversity of our topics and offering them more frequently. Today, we welcome our presenter, Conal Doyle, and although I've only known him for a short time, during our preparation for today's webinar, it was immediately apparent that he is passionate about the impact of his work. Conal is the founder and principal of Doyle Law in Beverly Hills. He is a well-known advocate for people with amputations in bad faith insurance and personal injury matters, and the combination of his legal expertise and personal experience as a prosthetic user is second to none. These unique features make him all the more beneficial to the prosthetists and patients he consults with and represents. And today we have the privilege of hearing his recommendations and insight firsthand. I will be rejoining the webinar at the end of the discussion to conclude and wrap up. There will be time for questions at the end of the presentation. We encourage you to use the chat feature to ask your questions, and we will be monitoring those pertinent questions throughout the presentation. Conal, thank you so much for sharing your time and expertise in this area. The floor, or maybe I should say the screen, is now yours.
Thanks so much, Kenny. I appreciate it, and thank you to COPA for having me again. I've done the presentation like this a number of different times over the years. This is the first one on screen, so I'm more comfortable, I think, like a lot of us, just up on my feet and talking to a crowd. And I usually recognize a lot of folks. I just want to start with a quick story, and I've told the story before, but one of my earliest childhood memories was in the Shriners Hospital in Montreal. I was born in Montreal, and I've been an amputee now for 50 years. I was born with PFFD, and I remember being in bed. I was a few years old. I was just had a major surgery on for the PFFD to fuse the hip, and I just remember this really distinct sort of smell, like glue, this like gluey smell, and the sun was coming through the windows at the Shriners Hospital in Montreal, which is up on a hill overlooking the city, and they had like elevator music on in the morning. I remember it was like Linda Ronstadt or something. It was like really peaceful, and this prosthetist, guy that turned out to be a prosthetist, came up to me and he said, "Hey, I'm a prosthetist. I'm here to make you a leg, get you up and walking." And I hadn't really had a prosthetic to that point that got me around very well. And I was so happy because I didn't want, my mom and my parents to have to take care of me. I wanted to be independent. And, ever since then, I've had a special place in my heart for this profession. And I've sort of dedicated a big part of my practice in the last, say, 15 years to helping prosthetists and helping their patients, amputees, try to navigate this crazy system of insurance that makes it so difficult for you all, for prosthetists, and of course your patients, to get the type of care and prosthetics that you really you need. I've been practicing law now for almost 25 years, and I kind of started more doing on the personal injury side. I represented amputees in personal injury cases and still do, but about 15 years ago, I started talking to a lot of prosthetists and realizing that this was a huge, in my own, my own situation, I've had claims denied. And then with my clients who, had lost limbs in auto accidents or whatever, I started really talking to a lot of prosthetists around the country and discovered that there's this epidemic of roadblocks that are put up to get good coverage, to get good care, to get good prosthetics for amputees. And so um, I have now, for about the last 15 years, I said, sort of been tracking the major insurers across the country, what they're doing, what their schemes are to delay and deny claims, and make no mistake, there are schemes to delay and deny claims. Um, so, and by the way, one thing I always get a question about this, but as I said, I've been doing this work for a long time, and I've always consulted with prosthetists for free. I've never sent a prosthetist a bill ever, 15 years. Um, I talk to prosthetists about their claims, how they're handling them, different insurance issues. Sometimes I get a case out of it where a patient was wrongfully denied and there's actually a viable lawsuit. And so my philosophy on providing help to this community is to pay it forward. And, every once in a while I get a decent case out of it. And that kind of makes up for all of the free advice I give out over the years. So if anybody at the end of this presentation wants to contact me as a question about anything, feel free to do it and know that, you're never going to get a bill. You just, I'm here as a resource to bounce ideas off and talk to. So what are we going to do today? Let me kind of intro what you can expect for today in the short time that we have. Um, so, all right, so I want to talk a little bit about, introduce some of the insurance company bad behavior that's been going on for a while now, the things that I've uncovered, some of the litigation I've been involved in, and sort of educate y'all as to what to look for. I think a lot of this is going to sound familiar to you, unfortunately, and some of you are going to know it better than I do, because you're living it every day. I'm going to talk about the basics of perfecting a claim and is try to give you some practical practice pointers to help you put your best foot forward in trying to obtain coverage, so you don't need a lawyer necessarily. And then I'm gonna do something that I haven't done in one of these presentations before, and it's in large part because in the last 3 to 5 years, I have been litigating some national class actions against various insurers. United Healthcare, I know some of you've heard about that action and that settlement. Anthem, Blue Shield of California, and also want to talk a little bit about individual actions for individual patients that we've represented, and what the possibilities are there for legal action, and also to kind of give you the lay of the land on the current litigation. I think I'm the only attorney in the country that's kind of specializes in this insurance class action. I believe that this United Healthcare class action, I think it was the first prosthetic class action that was ever certified and resolved. And we've got more coming. So it's been my sort of quest to make these insurance companies, act honorably and be a little bit more honest. The one thing I want to tell you up front that I'm not going to get into today is governmental benefit type stuff. So I know that it's a big issue with you all. There's, Medicare and Medicaid, and that topic is beyond the scope of the presentation, and also is something I don't get involved in very much. So most of the work that we do is going after the major insurance companies, and usually it's for the bigger ticket items, right? Because if you have a standard BK amputee, for example, and you put them in a standard old socket with a K2 foot or even a less expensive K3 foot, you're going to get a lot of those paid. But if you want to get the microprocessor foot, you have a microprocessor knee, you certainly with myo arms, you're going to have all kinds of problems getting reimbursement. So those are the cases that we tend to get. All right, so let me and one other thing. So we have about 45 minutes here, and then about 15 minutes at the end for questions. If there's a burning question that you think is really important, or it's timely and you want to kind of get it out, something that's confusing to you that you're just not understanding, let us know, and then somebody will bring that up. All right. So it's important to kind of take a step back when you're talking about insurance and just sort of understand some of the basics. So an insurance contract is not like a typical contract that you enter into, between two private parties with equal bargaining position. It's a special type of contract, and in California and in most states across the country, if not all, they've recognized that there is a duty of good faith and fair dealing in an insurance contract, really in every contract. But in the insurance context, it's a little different, and it means that an insurance company is supposed to um, look for ways to find coverage, to provide coverage, not to deny coverage. And that might sound very strange to some of you because it's probably been your experience that the perception you have is that they're doing the opposite, right? They're looking for everything, little thing to deny or delay processing a claim. And, you know, it's interesting because when you depose these insurance folks, they're kind of stuck in a tough position on this because they know that they're supposed to be looking for ways to provide coverage, but they hardly ever do. And you'll see that in some of these case analyses I'm about to get into. But with that said, here's the kind of underlying issue. I mean, is it in an insurance company's best interests to look for ways to find coverage, right? No, it's not. They're, they want to make money, and they will unfortunately look for ways to deny coverage. They do the opposite of what the law requires them to do. It's been my experience in over 20 years of doing these types of cases. They look to deny and to delay. And, one big question is like, how and why can they get away with this? What is it that permits them to do that? Why are they so cocky? Why are they so arrogant? Why do they just, after you fax documents to them like 3 different times, they keep telling you, well, we haven't got the stuff. Can you just resend it? And they have all these different things that they do. And we're going to get into some specifics in a minute, but there's an explanation for it. It's both law, legal, and human nature. And let's take the on the left side of the page is the legal first. So this is a topic where there's entire legal textbooks on it, so I'm going to short circuit it. But there is a law called ERISA. It's the Employment Retirement Income Security Act. I think it was of 1974 or something. It was passed in the 70s, and it was intended to provide like uniform coverage for say if you work for IBM, you wanted IBM to be able to treat their employees the same whether they were employed in California or Florida. So ERISA is a federal law that preempts state law. And a while back, the Supreme Court held that, health insurance plans are part of an employee benefit plan. They're governed by ERISA. Well, what does that mean? What's the practical import of that? Here it is. So in a state law bad faith case, where ERISA doesn't apply, and I'm going to tell you there's some exceptions and circumstances in which you can file a state law claim, and that's really important. But so when state law doesn't apply, when an insurance plan is gotten through an employer, and most people are employed and they have insurance through their employer, and it's a part of the employee benefit plan. Federal law preempts. What it means is, under federal law, you get a federal judge that decides your case. You do not get a jury trial. Federal judges typically, they don't even let you, a lot of circumstances, put on like evidence, witness testimony in court. A lot of times they want to just review it and decide it on the papers, on what's called the administrative record. There's no real remedy. So the most the federal judge can do at the end of a case is to say to the insurance company, well, you screwed up. You should have paid this claim, so now pay it. And for a lawyer that brings the case, the judge has discretion about whether to award attorney's fees, meaning that if, say, there's a $1,000 claim and the lawyer proceeds with it and gets the claim paid by the insurance company, he might be able to, or she might be able to submit a claim for the attorney fee time involved. The insurance company would have to pay it on top of that, say that $1,000 claim. But since a lot of these claims are smaller value, of course, some of them are bigger with, the myoelectrics and the microprocessor needs, but a lot of these claims are smaller. So no lawyers really want to do these cases and then hoped that a federal judge is going to give them some fees at the end of the day. The other thing is that there's a real deference to the claims administrator under federal law. Um, if your worst case scenario is the insurance companies, you're going to have to pay this claim probably that you've denied. I mean, what's the incentive to actually, you know, approve it in the first instance? I mean, it's got to be really clear that it's covered and inexpensive. So that's why you see the insurance companies taking these tough positions and these more expensive uh, devices and prosthetics, and also doing all kinds of stuff. And I don't have what they do. I don't have it better than I do. I don't have time to go into it, but just stuff. I mean, I just got a new leg, and 4 months, submitted the claim in September. In January, they still hadn't even ruled on the claim. They said, "Well, we've lost. You never sent in the records." Of course, we did. You didn't do this. You didn't do this. They string you out forever. I finally called an in-house counsel at Anthem, and I got her to process it. If I hadn't done that, if I hadn't had that connection, I'd be sitting here 6 months. I wouldn't even have a decision about whether my leg is covered. So they're doing all these kinds of things, and it's in part because of ERISA. There's a couple of exceptions to ERISA where if it's an individual plan, say an ACA plan, it's outside of ERISA. Those are potential good cases where you can go after the insurance company. They know that they have exposure because you get a jury trial, you get punitive damages potentially if you can prove it up, and general damages, pain and suffering, and inconvenience. So they're more concerned about those cases because they don't have to just pay the claim. Another big exception is government plans. So if you're a school teacher or police officer, you'd be outside of ERISA. So anyway, that's sort of like the background as to why they're so cocky and why they why they feel like they can do anything they want. And the other thing is this human nature, and it's on the right side. So, I mean, a lot of people are really just ignorant of their legal rights. I don't mean to use that word, ignorant in a pejorative sense. I mean, it's just, unless you're a lawyer, you're not going to, and there's a lot of prosthetists that don't know, right? That's why some of you guys are here. You want to figure out, well, what's the law here? What can we do? What are our remedies? So, there's a knowledge gap about what, and I'm going to fill a lot of that in today about what you can do. And there's a big fear of taking on the big insurance companies. There's a lack of resources, just an access to lawyers, because a lot of lawyers don't mess with these cases. It's not like a personal injury case where there's billboards everywhere, and if you get in an auto accident, you find a lawyer in a second. It's harder to find lawyers for these cases. And then the fear of rocking the boat. This is a lot of prosthetists, actually. So a lot of prosthetists I've found, they're like, well, I don't want to. I mean, I want to get in network with these folks, or I'm in network. I don't want to lose. I don't want to be kicked out of network. I'm afraid of what's going to happen to me if I push for the more expensive device, or if I, push back. And so because of that, there's so many, valid claims that are not pursued, and there's so much technology that's out there that's available to folks that they should have that they don't get. All right, so the question then becomes is, well, what do you do about this? Where do you start? How do you, when a patient comes into your office and you think, okay, this is the type of potential claim that's going to be problematic, and you guys know what those are. They're usually, any kind of a myoelectric arm. Somebody wants an X3 or a Genium. Sometimes just the entry level microprocessor needs are problematic. A C-Leg 4, a plie, whatever. I don't want to pick up manufacturers, but and then particularly the microprocessor ankles. I'm going to talk a little bit later about that because there's been some developments with the microprocessor ankles on some litigation I've been working on. So you kind of know where this is, where your battles are going to be fought. So where do you start? So this is the one thing that I've discovered that most prosthetists don't do, and I don't blame them. It's not because you're doing something wrong, but so when somebody comes in, you typically will, get the insurance card, and you'll call up and just see, well, are they current? What's the deductible? What's the out of pocket? If it's in network, what are they paying out? Is it 80% out of network? Is it 50%? Well, whatever. And then you get the basics, right? But what most prosthetists never do is actually get the insurance policy that governs the claim. And the insurance policy that governs the claim is not a policy that as a prosthetist you're party to, but you're a third party beneficiary of it because you're the one that's going to get paid by the insurance company for the services that you provide. So even though you're not party to the contract, you need to get the contract. And we're going to explain why. We're going to review some of these policies to show you exactly what I mean. But what you need is what's called the evidence of coverage, or EOC. Now, it's not, I've said to some prosthetists before, some patients, like, hey, give me the evidence of coverage. And they talk to the carrier, and and the carrier sends them a letter and says, well, this is a proof that you're covered from this date to this date. That's not what evidence of coverage is. Evidence of coverage is a term of art, and it just refers to the plan documents. And we're going to show examples in a minute. Summary plan description is sometimes synonymous with the evidence. This is why it's complicated. Summary plan descriptions some companies call the evidence of coverage a summary plan description. There's other companies that have an evidence of coverage, and they have a separate document that's a summary plan description. And then there's sometimes this schedule of benefits I talked about. It's usually in a chart form that says, well, out of network, it pays 50% of allowable amount, 80% if you're in network, the deductible and all that. You've seen those. And then finally, there's these written medical policies that are not contained in the EOC. And those are the documents that you all are probably most familiar with. So, for example, you all know, Anthem has, or United Healthcare has, a written medical policy on lower limb prosthetics or microprocessor technology. And it'll say the circumstances in which they'll pay out, and and they'll have citations to the records. I'm going to show you one in a minute as an example, but those policies are not contained in the EOC. They're not given to the insured at the time they sign up for the insurance plan, and they are not binding. They're not part of the contract. So, an insurance company can create any policy they want. I mean, it's got to be reasonable. There's things they need to do, but you can challenge that policy and say, oh, no, that policy is, pardon my French, is bullshit. This policy doesn't work. It's not right. It's outdated. It's not in accordance with medical principles. So we're going to show you a couple that I've got some carriers to change and how you do that. But so don't just think because there's a medical policy that says, well, they don't cover something, that you don't have any recourse, because you do. Okay, so how do we read an insurance policy? There's usually a section that says what is covered, and then there's one that says what is not covered, or exclusions. And so the language is a little different with all of them. Let me see what the next slide is. I think this is the point where I want to show you some examples. Okay. So real quick, how they justify denial. Here's what they usually do, as you guys know, because you get these denial letters. I mean, they sometimes specify policy language from the EOC, but rarely. Usually they'll make a decision based on medical necessity, or whether it's experimental investigational. So right now, if you're trying to get a 5973 code, a proprio type foot, or even like the Empower, what's that, 5969 or something, forgot the code. But if you want to get this microprocessor ankle technology from Anthem, from Blue Shield, they're just going to say no, it's investigational. Doesn't mean you can't challenge it, but that's where they're going to go with that. On a knee unit, like say a C leg, they're going to make a medical necessity determination and say, well, you didn't prove up medical necessity. And they usually don't specify policy language, but sometimes they do. So let's show some policies here, and I want you to see this so you know what to look for, because I think you should make it a practice to ask your patients to give you these. It's easy to get now, a lot easier than it was, say, 5-10 years ago. Most of them are online, although sometimes they got to go through their employer benefit plan person to get the evidence of coverage, but a lot of times it's online. So let's look at a few of these, and we're going to use them. My bar up here is sort of taken up. move this thing. All right. So let's look at some policy language. The first one I want to look at is actually a United Healthcare one. I've got a Blue Shield of California one to show you. Got an Anthem one, and I pulled a United Healthcare one. All right. So the United Healthcare plan I've got right here. United Healthcare, they call it a summary plan description. It's actually the evidence of coverage. So what you do when you get a plan like this is you just go to the table of contents. It'll tell you real quick. I mean, I've gotten to the point where I can, and you will too, be able to read one of these policies in like 2 minutes and figure out what it says. So here's the table of contents. You kind of look down here and you just look for stuff. And here's a section that says additional coverage details. It's a little harder to figure out what it is. Some other plans you'll see will just say what is covered, but the additional coverage details. And you look and you say, okay, all right, well, what is there? Does it reference prosthetics? Oh, it does. All right, prosthetic devices. So that's easy. You go to prosthetic devices. 47. All right. I'm assuming everybody can see the screen and is able to see this policy. Is that fair to say? I got a thumbs up from Maynard. Great.
Yes.
All right. So here is a United Healthcare evidence of coverage on prosthetic devices. All right. So let's look at the first section of this. All right. It's easy to find. It's easy to read. Boom. So it says benefits are paid for artificial arms, legs, feet, and hands. Now, in a lot of policies, you'll see a couple of others. That's all it will say in the section about what's covered. It'll just say, look, and it has no limitations. It's very general. So you can basically argue anything, right, under this language. But this United Healthcare plan has some different language that you needed to read down and understand, and it'll help you in putting together your letters of medical necessity. All right, so it says here, if more than one prosthetic device can meet your functional needs, benefits are available only for the prosthetic device that meets the minimum specifications for your needs. That's kind of a mouthful. It's even hard to figure out, what does that even mean, right? It's just, so I litigated this language for a couple of years, took 20 depositions, and the people that are interpreting this language don't really know what it means. But basically it's saying, look, you get the most basic device. But here's why it's important to read this, because now if it says if more than one prosthetic device can meet your functional needs, benefits are available only for the prosthetic device that meets the minimum specifications for your needs. The key language here, though, is it's got to meet functional needs. So so the most basic device that doesn't meet the functional needs of the amputee is not the right device. So this language is really important for you to know about and be able to craft your letters and work with your other medical providers to get the right language. All right, so this is one example of so there's an exclusion section that you got to read as well. So here's in this exclusion section, it says, devices used specifically as safety items or to affect performance in sports-related activities. Those aren't covered. This is an exclusion. So this is why it's important to read both. Excuse me one second. So it's important to review both what's covered and what's not covered. The covered section kind of giveth what you can get, and the exclusion sections take it away. And the reason you can see why this is important, because I read a lot of letters of medical justification from both doctors and prosthetists, and a lot of times what you'll do, if you've got say somebody that's really into sports activities, you're going to say, oh, I mean, this person runs marathons, he does whatever, and you're going to really focus on the sports related activity that this person really does as justification for getting the device. And if you're like pleading into writing your thing into an exclusion like this, you're giving them a rock solid basis to deny the device. So this is kind of a highlight of why it's important to read this stuff. There's other provisions that say, um, you don't get it for school related stuff or work related stuff. So it's okay to sort of document in the history section of your examination, like, well, what does the person do for work and social and all the activities? But when you're making the claim for the device, talk about it in terms of activities of daily living. So ADLs, just in general, without tying them specifically to a sport or work, but some plans don't have the exclusion for work and for school. So that's why you got to read these plans, so you can see why there's some landmines out here in the actual evidence of coverage, the document that governs the case, that if you don't know about, you can just sort of write into it what you're gonna and get denied. So I don't want to spend too much time on this. I want to see if there's anything here. Like, here's one. This is an anthem. So it's harder to find, but it'll just say artificial limbs or eyes, exclusions. And they don't really have any exclusions. That's a real general one. So they're all a little bit different, which is why the point is you kind of got to read them all, because some of them are listed as prosthetic devices, some of them are in DME, but you can find that out. So let me just kind of get back to, and there's, in the exclusion section, there's always a medical necessity and an experimental investigation, which is how they're going to deny it. All right, again, the written medical policy, it's often overly restrictive, outdated, or medically flawed. I'm going to get into a few of these in specifics. So hold on one second. So kind of, I'm going to get into now like what an overview of some of the litigation that we've done, some of the headway we've made on attacking some of these policies, and then the practices out there that United was engaged in and how we address those. Well, here's something that you all have seen, kind of what insurance companies can do. Otherwise, it might be hard to believe that this stuff goes on. But here's a clip from a movie that it's a little dramatic, but
I hope that you are astonished, as I am, at the lengths to which a wealthy insurance company like the defendant will go to take money from a low-income family and then keep it by denying a legitimate claim. It's no wonder they spend so much money on their lawyers, and their lobbyists, and their public relations machine to convince us we need tort reform, that we need to put an end to punitive damages. I'm asking you, the jury, just do what you think is right in your hearts. If you don't punish great benefit, you could be their next victim. That's it.
So this is kind of setting up. This is what I do. So I bring cases against the insurance companies for denying claims, and I've talked a little bit about kind of the lobbying and the system and everything is really set up so that it's very difficult to win. But we've had some successes and we've changed some things, which I'm going to talk to you about now. All right. So United Healthcare, some of you all have heard about this class action settlement. I discovered, I don't know, maybe 5 years ago that United was doing a couple really, really bad things. So we talked about this policy language before. I just showed it to you, the United policy, and it says if more than one prosthetic device can meet your functional needs, benefits are available only for the prosthetic device that meets the minimum specifications for your needs. So with that, so my argument was on this is that, look, this language says, it says, look, if there's another prosthetic device that would suit you, but it's cheaper, basically, you get that. But how do you know, right, whether there's an alternative device that would be just as good for you, for the patient, without identifying that alternative device? So what I suspected is that none of the medical directors were really doing any analysis to determine, well, you know, what's the alternative device that would meet the minimum specifications for the patient's needs, and actually doing a proper analysis of this language. And so we filed this lawsuit, we got into depositions, and my suspicions were right. So the denial letters, when United was going to deny a claim under this language, they don't identify an alternative device that the patient would need, and they don't inform you that some of the codes are approved. Basically, it's like, hey, guess and try again. And let's show you one to make it a concrete example. All right. So this is the rationale, basically, right at the top here, per Dr. Browning. The request for an artificial leg was reviewed. We looked at the case notes and documents. We looked at your health plan and its policies. The notes show you were in an accident. The notes show you the leg amputation. The vendor has asked for a hi-fi socket. Your health plan covers the most basic device that meets your needs. This request is not the most basic device. The denial is upheld. Please talk about this with your doctor. So, as you all know, of course, you know, on any prosthetic limb, there's going to be 10 L codes at least, usually, right? There's all kinds of stuff that's perfunctory. You know, there's liners, socks, pylon, foot, right? In this particular case, they didn't like the hi-fi socket, but because it was built with L5999 codes. And so you can see this, the language of this denial letter doesn't tell the patient or the processed anything. It just says, well, you know, this is not the most basic. We're not going to tell you what the most basic is. Just try again, just guess, and just keep submitting the claim. So what it does is it creates a scenario where, you know, you as a process, you're just guessing. I mean, you probably, as the process, probably have a pretty good idea what might be covered, right? But you basically just can just keep resubmitting the claim, and then take a couple months, and just, you're in this never-ending cycle. They don't tell you. They don't tell you that, hey, we'd approve these 7 L codes. You just got to switch the socket or whatever. So what we did is we did a deposition of the subject matter expert in prosthetics, United Healthcare. They call it an SME. The subject matter expert in prosthetics at United Healthcare literally had no education, background, or training in prosthetics whatsoever. He was a high school dropout that had a GED, no medical training whatsoever, no post-secondary education. He had worked in the best he could do is, he said he had a buddy that was a prosthetist, and he worked in the back shop, and he kind of did some fabrication, not as an official employee, but just when he went to visit him, he tried it out because he was interested in it. That's it. And this guy trained the United Health Care medical directors, these are PM&R doctors, on how to process claims. And there's written stuff where he would say stuff like, well, you know, most prosthetists overstate their patients' K levels, saying, you know, they're really a K2 or a K1, but the process will say they're a K3 to get the more expensive technology. That's what he was training these medical directors. And he said stuff like, well, most K3 ambulators can do just fine with a K2 or a K1 knee. So we filed this lawsuit, litigated over a period of time. It was really intensely litigated. They didn't want to settle the case. And then finally, the federal judge just reamed them at a pretrial conference saying, why in the hell have you not, literally, why the hell have you not settled this case? I don't understand it. You know, this notice, this letter is ridiculous. It doesn't, you know, inform the patient about what he can or can't get. And so in this case, we obtained all of the relief requested, which was to change all their practices moving forward. They are supposed to inform the prosthetist and the patients what codes are covered, and if something's not, an alternative code or device that would be covered, they're required to reprocess prior claim denials and repay patients that had denials with Swiss insurance companies. We're in the process of this reprocessing right now and getting the data back. This settlement was about a year ago, and so they still haven't given us the final report on what they've done, but they have allegedly changed their practices. But then I got a case out of Colorado where they're doing the same thing. So I'd love to hear from anybody if United Healthcare is sending these same denial letters out. All right, so I'm got a little bit more time, not a lot. I want to talk a little bit about a couple of other class actions I've got going right now. So I've got a national ERISA class action against Anthem. We're seeking injunctive relief as to two policies, the microprocessor knee and the ankle. And so again, a policy looks like this. This is a United Healthcare, not the Anthem policy, but you've seen these, right? These coverage determination guidelines or policies on what's covered and what's not. And they just publish these, and they're available on the internet. So Anthem had one that had criteria for for the MPKs, and also determined that the ankles were experimental investigational. So we have obtained a settlement with Anthem on the knee. We've got them to change their knee policy. I'll go over that in a second. The ankle, they've been litigating it tooth and nail. I just took the deposition of the head of their medical committee a couple months ago. This guy has no training, background, experience in prosthetics. Didn't consult a prosthetist in developing their policies. They don't even have on this committee, which is like 20 or 30 medical doctors, that creates medical policy nationwide for United Healthcare for every type of medical claim. They don't even have a PM&R doctor on that committee. And so, they basically, and as you all know, look, I mean, it's hard to get really great, robust studies and with large numbers and everything with prosthetics. And so they're claiming that the prosthetic studies aren't adequate enough. So they've just contacted us literally in the last last week. I have a call at 2:00 with the lead lawyer for Anthem, and they have signaled a willingness to change their policy on microprocessor ankles. And so right now we're just going to be talking about the language. I'm pushing for the Medicare language, which just says, hey, if you're K3, you can qualify for the ankle. So we'll see where that goes. The knee language, so the old language was like left over. I think it was created by the VA in 2000, right? Like a year or two after the C-leg first came available. And they had all this stuff in here that was just stupid. Like, talking about faster than normal walking speed as if a microprocessor knee, the benefit is to walk fast when it's not, right? It's for safety and stability. So they talked about walking faster than the baseline rate, got them to change that. This is the old policy. It documented need for daily long distance ambulation. And so it was vague here what that meant, greater than 400 yards. Does that mean like 400 yards at a time? So you'd have to say, well, your patient, walks 400 yards at a stretch every day. Who does that? And they're saying, well, just with use within the home or for basic community ambulation, whatever that is, that's not sufficient to justify. And so we got them to change their policy. Here's the policy. This has already been changed. So anybody looking at doing these cases, you got to be aware of this new policy. And look, you got to tailor your medical necessity justification to make sure you address all these points. So what we did is we negotiated this language that an individual has demonstrated a reasonable likelihood of better mobility or stability with the use of a microprocessor controlled knee instead of a mechanical knee. So we focused on what the real benefits of MPK technology is, right? It's better mobility, which is vague, or stability. And that's what it's really all about. And you can demonstrate it with prior effective use of a prosthetic, use of a temporary device, or we negotiate a nice broad catch-all provision. When unable to complete such a trial, the provider documents or attests that there's a reasonable likelihood of improved mobility or stability. Easy to Easy to do, but you got to know what the language is, which is why you got to read these policies and make sure you include it in your letters of medical necessity. And then again, and then either of the following in addition, has a documented need for daily long distance ambulation. So we fought hard to get this language in, greater than 400 yards cumulatively, because they didn't want the cumulatively, because an average person like walks 3,000 to 4,000 yards a day. It's really easy to meet this 400 yards cumulatively a day, even for an amputee. It's very easy. If you're just doing anything, you're going to meet that criteria. All right. So let me just see what else we got here. So Kenya, we've got, I don't remember when we started. What time do we have until? So I want to leave some time for a few minutes for questions.
Yeah, we still have just over 10, a little over 10 minutes left.
Okay. All right. So let me just wrap up on some of this. So to leave you with some practice pointers as to how you can kind of help with these higher ticket items is, you know, I talked about this, read the EOC, make sure there is coverage, obtain the relevant medical policy. This is something that's really important. I think probably a lot of good prosthetists already do this, but you need to develop a relationship with a medical doctor that you can refer your patients to, preferably PM&R, but it doesn't have to be, to document medical necessity. And you've got to, I mean, it's hard to do this. It's hard to develop the relationship and get them to work with you, but you need to train them. I mean, you got to, because these doctors don't know prosthetics. They're not trained on prosthetics. So you got to train them, and you got to, sometimes that means writing a template and then, you know, sending it to them so they can use it and have it in their system and they can modify it for your claims. And then, you know, tailor the documentation of medical necessity to the policy terms. We showed one with the minimum specifications test. You got the MPK policy language as an example. You might not, I mean, not always, but you might not want to emphasize work or school if you have a policy provision that says, well, we don't provide things primarily for work and school. I mean, you can talk about it in the history, but don't say this is for X, because that, you know, could be an exclusion. Include studies, especially if their policy is inadequate. Because a lot of these medical policies, like one I'm looking at right now, the myoelectric partial hand prosthetic, they've got like one study from 2010 that really isn't about myoelectric hands. And there's a bunch of studies that have been done in the last 10 years. So you include those. All right. And then finally, you know, these appeals and grievances, they don't usually work. You can get an attorney involved. I'm always willing to consult at no charge. One of the things I do, I mean, some cases I can get stuff done really quickly. Some insurance carriers, Anthem, for example, once, you know, they deny a lot of claims, but once you catch them denying a claim, like I can get them to reverse the claim pretty easy. Others, Blue Shield of California is very different. They fight everything. United Healthcare tends to fight. Sometimes what I'll tell patients is, look, you just need to get on their insurance plan and resubmit it, because this plan just isn't going to pay for it because it has a particular exclusion. But sometimes when you file the appeals and do the grievances, it makes it worse for you because they send it to some out of supposedly independent outfit, and they will then shut it down. And then you've got an independent person that says, well, it's not, you know, it's not right. So it's better to talk to somebody if you've got a big ticket item that's important to the patient and to your practice before actually even doing the appeal or filing the grievance. So I know there's a lot of info, and at the times just seemed like it flew by, but what questions can I answer?
Conal, I'll start off the questions. Have you seen anyone in those documents where it says it excludes for work or for school or for sports? Have you seen anybody be successful in maybe trying to tie that towards the patient's mental health and helping to create even a broader, more well-rounded picture of the patient as a whole and getting it approved in that fashion?
So I'm not sure I totally understand the question, but I mean, look, you don't want to get too cute with these things. I mean, you definitely don't want to like write the medical justification that's going to drop it right into a clear exclusion. So I don't think that the mental health angle is going to be particularly effective in getting claims paid. I wouldn't do it. I wouldn't recommend it. I would focus on activities of daily living. I'd make sure to understand, well, what's the standard of review? It's a legal term, but that's can be used here. Standard of review, and you got to look at the evidence of coverage. Is it a minimum specifications test if it's United? Is it something else? Is it, well, the most cost effective? And you got to be able to fit it in to what the coverage language says and stay away from the exclusions. Doesn't mean you don't mention that they're active in work and that you just got to in the history section, but when you're doing the justification saying why they need it, it's because his activities of daily living require him to do X, Y, and Z, and this is the only device available that will permit him to do it. And if you have a minimum specifications thing, you know what the alternative device is. Like, for example, you have a Mayo hand, and they want to give them the hook, right? Insurance companies want them to get the hook. And some patients, it's fine for certain conditions, and you want multiple prosthetics. But if you want somebody that wants an IO hand, you got to tell, look, the hook, the body powered, is not going to work because X, Y, and Z. It doesn't meet the minimum specifications. So I would say focus on staying within the coverage parameters, what they say they're going to cover using their own language, and stay away from the exclusions.
Okay, there's a question coming across in the chat box. It says, have you come across cases where outcome measures to measure balance and or functional ability were on file and could be used to fight a denial? And has there been any trend that shows that they are beneficial?
Can you repeat that question just one more time, please?
Absolutely. Have you come across cases where outcome measures, specifically ones that are measuring balance or functional ability, were on file and could be used to fight this denial or fight a denial?
Yeah, I mean, sure. Outcome measures are important and document. So you here's the thing though. You need to provide the insurance company all the stuff that you have in your file. So especially with ERISA, the law actually says is that the only thing you can rely on is the stuff that the insurance carrier had. So if you have all this great documentation in your file and you don't send it in, it's not in the administrative record. It can't be considered. So you just got to make sure that you have a clear in your files. You've got to have clearly identify what was sent into the carrier, not just so if you're going to fax something in or upload something, identify this is a 27-page fax or 27-page document that contains X, Y, and Z, put it in a cover so you can just show afterward what was sent in. But anything that would tend to document the need for the device is obviously very helpful.
Conal, there have been a few people that have asked for a copy of the PowerPoint presentation. Is that something you're willing to share with the group?
Yes, it is. Yeah, I talked about that with COPA. I will share it. Let me just tune it up a little bit. I didn't get to polish it the way that I would have liked to before today, so I'll tune it up and get and maybe add some stuff to it and get it to you.
Great.
But one of the things that's a lot of these cases are like case by case basis, right? So because every patient's a little different, every situation is different, the language and the policies are different. So, at some point, if anybody has any questions, don't hesitate to call me. I'm easy to find online, conaldoylelaw.com or amputeelawyer.com. That's an easy one to remember. I'll try to call you back as soon as possible. I usually get back to people within 24 hours. And, again, I'm happy to review stuff for free. It doesn't take me long to kind of cut through this stuff and figure it out and kind of give you more specific advice. Because usually generalities are very hard. right? So I need to see the contract, the denial letter, the reason for the denial, the medical justification, and then put it together and figure out, well, where do we go from here?
Well, Conal, thank you so very much. That was a really wonderful presentation. I think there's a lot of information that people are kind of taking in, and we might end up having more questions afterwards. We really appreciate the time that you've taken out of your day for us. And now, since we only have a minute or two left, I'll start to close out our webinar. As the chairperson of our Education and Advocacy Committee, I would love to thank all of our attendees for your time and your interest today. To our members, thank you so much for your support. COPA relies on your membership and your feedback from events such as today to continually improve the content we're providing. Our next webinar will be on Tuesday, March 23rd. Our speakers are Mark Higley and Craig Douglas from VGM. They will be speaking on competitive bidding. They'll be sharing updates and insights about contracted providers and reduced reimbursement for OTS knee and spine braces within this competitive bidding landscape. And registration for that event will be emailed out later this month. We look forward to seeing you all then. Thank you guys so much, and I hope you all have a terrific day.